Good morning, Glen Smith with Smith Elder in Business Law, and today we're going to be discussing powers of attorney, specifically durable powers of attorney. What is a power of attorney? Well, it's simply a document that you appoint someone to act as your agent, sometimes called an attorney in fact, that you authorize to take an action, sign a document, or a series of actions on your behalf. Whom can you appoint under a power of attorney? Well, you can appoint any adult. Oftentimes it's a relative, a child, a sister, brother, parents, or some other trusted individual. How many folks can you appoint as your attorney, in fact? Well, you can appoint more than one. You can appoint them consecutively, whereas you have one person that will be the primary and that person is unavailable, then you have a backup or second. And oftentimes we want 3 levels. Or you can appoint more than one person to operate simultaneously. And we typically want those people to be able to act independently. What is a durable power of attorney? Well, typically a power of attorney terminates when the principal, that's you who signs the document, becomes incapacitated. But a durable power of attorney actually survives your incapacity and continues forward to be effective. Generally, there are 2 common types of durable powers of attorney for estate planning. One that we'll talk about today is the general durable power of attorney for financial matters. The second type is a healthcare power of attorney for health and medical matters, and we'll cover those healthcare documents in another episode. Now, why is a durable power of attorney for financial matters an important estate planning document? Well, first of all, it avoids conservatorship or conservatorships in probate court. If a conservatorship is filed, then there will be a hearing. You have the right to a trial by jury, and your relatives typically will have to come and testify. Worst off, the court then becomes in total control of your estate. It also provides you and your family options and opportunities in the event you become incapacitated. It allows your agents, your family, to obtain the care you need without becoming impoverished. And typically what I want to say is, if you don't do what you need to do, when you need to do it, somebody else will do it for you, and that's typically the courts, and you and your family are not going to like it. Now you may say, well, Glenn, I've got a durable power of attorney. And I'll say, well, maybe you have one, maybe you don't. But oftentimes I review these powers of attorney that have been drafted by others that I call Yugos. They're good for something, but they're not good for much. It's kind of like the Yugo car that was manufactured in the 1980s. They were good for something, but not good for much. What you need is a durable power of attorney for financial matters that has enhanced powers. Those enhanced powers are beyond what the statutory provisions provide, but specifically the enhanced powers would allow for additional estate planning, such as the creation of trusts, the transfer of assets, for caregiver agreements, for the modification of beneficiary designations and insurance policies. And in the absence of those enhanced powers, then typically your agent cannot undertake those actions to obtain the care that you need and avoid becoming impoverished. Who needs a durable power of attorney? Well, it's anyone that's 18 years old or older. Frequently, I have parents that come in to talk with me, and they are shocked that they no longer have access or the ability to help their child once that child becomes 18 years of age. And there is no access, there is no decision making based solely on a relationship, whether you're a parent, a spouse, a partner, or a friend. You have to have it specifically authorized in a document. When does a durable power of attorney become effective? Well, it depends. Generally, a durable power of attorney can become effectively immediately, and typically this is someone that's advanced in age or has poor hearing, has issues getting around, and they want to go ahead and appoint someone to act on their behalf. Or you can make it contingent. It's contingent upon you being declared incapacitated by 2 licensed physicians or by a court of law. And typically, an elder lawyer will also provide for a third option, which says it's contingent now, but I can sign a document that's embedded in the durable power of attorney, which makes it immediately effective, because most of my clients may need help in the future, but they really don't want to be declared incapacitated in order to get the help that they need. Now, from an elder lawyer's perspective, from protecting your assets and allowing you and your agents, your family members, to be in control of your life without going into a probate proceeding and without becoming impoverished, a durable power of attorney for financial matters is the absolute most important document you can have in place. Remember, don't wait till it's too late, because if you don't do what you need to do when you need to do it, somebody else will do it for you, and that's usually the courts, and you're not going to like it. Well, have a great day, and it's been good chatting with you.